Hey everybody, welcome to Thursday night. We're back here once again on Thursday Night Live, where we talk about all things debt, bankruptcy, debt collection lawsuits, strategies, tactics, just kind of understanding the process. I'm consumer attorney John Skiba, and I work in the state of Arizona, and I help people with bankruptcies, defending junk debt buyer lawsuits, all those kind of things. So each week we meet here. You're allowed to put questions there in the chat. I'm going to put them up on the screen, and we're going to talk about it. My normal disclaimer that even though I'm a licensed attorney in the state of Arizona and I can help you if you live here, I cannot provide any legal advice through this YouTube channel. This is just information, and if you need assistance, I highly recommend you contact an attorney in your particular state. All right. When getting started tonight, I'm going to do one more plug for my Facebook group. Oh, that's the wrong one. I got to figure out how to do all this tech myself here. But I have a free Facebook group. It's a private group where we can kind of take some of these discussions offline. And that's the website to it. Just go to Facebook. You can even search for Consumer Warrior, put your name in there, and I will approve that. And we can, like I said, go into a little more depth here. You can learn from other people that have gone through some of the things that you're likely going through and get you some better help that way. So, all right. What I wanted to talk about today, just in launching, well, again, if you have questions, go ahead and put it in the chat there and we can talk about it. I've been watching this trial that's on, it's being blasted on everything about this kid that, gosh, now you know what, I'm blank. I got to look it up. Now that I'm doing this, I'm blanking on the kid's name. But this kid where there was a shooting during all of the, during these protests a while back. And I'm looking on my phone to try to figure it out. I'm going to find this. Someone's going to help me out here for a minute. Anyways, you probably all know what I'm talking about. This trial, it's been on TV, this Rittenhouse kids trial. I obviously don't want to get into any kind of politics of that, but something that's kind of interesting is I've watched that. And if you've watched any of the coverage of it, something that I thought you can use that can help you in defending a debt collection lawsuit is the jury system. If you've watched a little bit of it, there's a couple clips I've seen where this judge is just reaming this prosecutor. And I've talked to other attorneys. I'm like, man, how would you like to have like your worst day on the job be like televised to the whole world? But so often what you'll see is the judge will dismiss the jury will go back into this library area, and then the judge will talk to them about procedure and things like that. It is something that's available to you if you're being sued by a debt collector is you can request a jury trial. Most of these are done via bench trial, but you can request a jury trial. And if you find yourself in a jurisdiction where judges are often ruling against consumers, if you feel like the judges just don't listen, if you feel like they're favoring or there's a bias towards the collector, you can ask for a jury trial. Now, doing a jury trial as a pro se or a self-represented person is going to be difficult. There's a lot of attorneys that are scared to death of jury trials. I can tell you that just because they don't happen that often. But that's an approach I've taken in some of our courts. I'm starting to set these things for jury trials because I feel like if I would rather, because the background on this, if a case goes to a jury trial, it's the jurors who make the decision of whether you're liable or not, or whether the debt buyer has proven their case or not the judge. You see that in the Rittenhouse case. The judge is kind of there to guide the evidence coming in and out, and judges are a lot more strict on what evidence comes in when there's a bunch of jurors there, rather than if it's just them who's making the decision. So something to consider. It's kind of one of these advanced level techniques. You usually have to request the jury trial usually right at the beginning. There's a deadline. So you got to check the rules of civil procedure in your state. But it's not a bad approach right from the beginning to tell the other side, hey, if this is going to go to trial, I want a jury on this thing. And you'll get the court will give you grief over this. The opposing counsel will give you grief over this. Just stick to your guns on this. It'll put you in a lot better situation to maybe get a good settlement or get the whole thing thrown out completely. So, all right, we have our regulars here who support the channel each and every week. Dave Lamb, thank you, as well as Marcos. Thank you so much, sincerely, for supporting that. All right, let's jump into some of the questions here. And I try to kind of piece everything together the best I can. We'll go with Maria, who's here first. She says, hi, I settled with a debt collector, and they said that they're going to send me a letter of stipulation. That was over a week ago. What does that mean? Okay, here's what I'm going to guess that this means. But my guess is based upon doing this for about 20 years. You settled the debt. So my guess is that the lawsuit's been filed. They're going to send you a stipulation. If you've settled the debt and you're making payments on it, let's say you owe $5,000 or they're claiming you owe $5,000 and you're saying, hey, I can pay $150 a month on this until it's paid. They're not going to keep the lawsuit open for 5 years. No court's going to do that. And so what they'll have you do often is enter into what's called a stipulated judgment. Sometimes we call it pocket judgments. And what it is, you're signing off on a judgment, but there's terms in the judgment that say that you're going to pay whatever it is, $100, $150 a month, and that there's something called a covenant not to compete. So long as you're making those monthly payments, that they are not going to garnish your wages or try to go after property. They're going to allow you to make that. But if you stop making payments, then they can take the judgment, file it, record it, and try to collect on it. So it's kind of like their insurance policy that they're saying, hey, we'll stretch this thing out for 1, 2, 3, 4, even 5 years I've seen. But we get this stipulated judgment. We'll keep it in our pocket. And then as long as you're making those payments, then we're good. So that's likely what they're saying. It's not unusual for it to take over a week. Particularly, you got to realize with debt collection firms, they have thousands or tens of thousands of cases. Even on the defense side, we have a lot of cases that we're working through. And so I know it's kind of frustrating, but it does take a little while to get everything through. So that's, I think, what you're dealing with there. All right. Let's talk about a bankruptcy question here. I'm in Arizona, Chapter 13. I want to ask about having a bank account for a child. And with that said, do I have to report it to the trustee? And does a trustee look over your transactions? So the answer is if you're on the account, it needs to be disclosed. However, in the schedules, it can be notated that it's a minor account, that the only reason the account was opened up was so that your kids can put, money that grandpa gives them or whatever in there. Now, usually you don't have to provide those statements as long as you're showing that it's a minor account. Or even if you have to show like a month or two, if you're not depositing money in there, then it's not going to be a big deal. If you're using the account by chance, like if you're depositing funds in there that are your money, or if you have a paycheck going into your kid's account for some reason, that's going to be a bigger issue. I mean, it's not going to be a problem, but it's just a disclosure issue. When it comes to bankruptcy, I always say it's best to just be fully, open book, disclose everything. You'll have less problems going down the road. You'll develop some trust and rapport with the trustee. But your kids' funds aren't going to be subject to any kind of risk. Plus you're in a 13, so you're not going to lose any assets anyway. But yes, so I would disclose that. If you're in a 13, you usually have an attorney. I always defer to the attorney. So if they tell you something different, I would do what they're telling you to do. All right, let's see what else we have here. See Jerry. Jerry says, sued by LVNV, provided copies of monthly credit card statements from Citibank and an affidavit of sale, but no original signed application. Is this lack of a signed application a good defense? A number of years ago it would have been, because, in the old days, they used to literally send credit card applications to you like in the mail, and you could sign it. You fill out the annual salary, sign it, and send it back in, and then they would let you know if you've been approved for a credit card. 99.9% of all these things are done online now, and so there's some electronic signatures. So in most situations, they're not going to have it. And I can tell you, like in Arizona, the legislature and the state statutes have recognized that. And so in Arizona, they can prove the existence of the underlying contract of one of two ways. One is they can have the signed agreement, and sometimes they do. I see that with Web Bank, Lending Club, those kind of things. Sometimes they'll have the actual electronic application. But often, under Arizona law, what they say is they can prove it through what's called a course of dealing. And that's why they'll provide you that big copy of monthly statements, because the court can then infer what the terms of the agreement are, as long as the statements show payments and charges and payments and charges. One thing to be careful of on that and be aware of, if they just send you like the last 12 months of statements and there are no charges and no payments on it, that is not evidence of a course of dealing. That's just a statement of what they're claiming is owed and maybe the interest is. It doesn't show your assent to those terms because you are not making the payments or you're not using the card. So that's something to be careful of there. All right. See this one here with MM. Midland Funding filed a motion of voluntary dismissal without prejudice yesterday, 10 minutes before court closed. Can I get this changed to be with prejudice? Usually, I mean, it kind of depends why they're asking for it to be dismissed. But I can tell you this, and this is a good point that you're bringing up here. Once you file an answer to the lawsuit, the plaintiff is not allowed to just withdraw the lawsuit. They can't just say, never mind, we're not doing this. Because, you have some skin in the game now. You filed the answer, you paid the filing fee. And so sometimes what they'll do is they'll file a motion, or they'll ask you to stipulate to be dismissed. That's not what happened here. They filed a motion to dismiss the case. You have the opportunity to respond to it. You can file a response to the motion for the dismissal and ask that it be with prejudice. You're going to need to provide some specifics, like maybe, particularly if the case has been pending a long time, you've had to incur expenses or filing fees, all that kind of stuff. You can ask that it be dismissed with prejudice. They get a chance then to file a reply brief. Now, the rules generally are going to allow at least, 10 days to file a response. I would file something quickly. I don't know if you're in Arizona or not, but in a lot of states, at least in Arizona, I can tell you, sometimes the judges act quickly on these things because it just gets another case off their docket. But I'd file a response to it. It's probably kind of a long shot that the court will grant that. Often when it's dismissed in a situation like that, unless there's been some prejudice to you, like they're filing it on the eve of trial or something like that, you're going to get a dismissal without prejudice. But the thing to know, if they dismiss it, the statute of limitations, it's as if they never filed the thing. And so you need to go back and see when the statute of limitations was, because I've seen debt buyers do this. They dismiss it, and while the lawsuit was pending, the statutory period passed. So in Arizona, it's 6 years. If they waited till 5.5 years to file that thing, and then it got dismissed 6 months later, that's going to cause them a problem. So take that for what it's worth, I guess there. All right, Dave, let's see what you have today. Okay, you're talking about the trial, and the DA is something else. He is. I used to be a prosecutor early on in my career. I was a prosecutor for Maricopa County Attorney's Office. That's why it's kind of bizarre to kind of see it play out like it is. This is that trial that's on TV we're talking about. They moved for essentially a mistrial based upon some of the stuff that's going on there. Purely from a legal perspective, it's wild. Attorneys are watching this, and they can't believe, one, the behavior of the prosecutor as far as the legalities of it, the approach of it, doing things that you're not permitted to do. And then two, the judge is he is just screaming at this dude. I truthfully, I don't think I've ever seen a judge do that as vocal as he's being. I mean, they'll say things. Sometimes it's in writing and it feels like they're screaming at you like that, but it's kind of an interesting thing. All right, let's jump into a bankruptcy question. How long after the 341 meeting of creditors can creditors still object to your Chapter 7 discharge? Do most bother if it's a no asset case? All right, Rick. So the 341 meeting of creditors happens about 4 to 5 weeks after a bankruptcy case is filed. And this is Chapter 7 specifically. So what you can do, it's usually about 45 to 60 days after the meeting of creditors. And if you look, now when you filed your case, they sent out a notice. It'll say notice of 341 meeting. The court sends this out. You'll see on there that there's some dates, and there'll be a date set by the clerk of the court where creditors have to file an objection if they don't want their debt to be discharged. And so that's the specific date. I believe it's 45 days after the meeting of creditors. The first setting for the meeting of creditors, they have to file an objection. Otherwise, they waive that right. Most do not. I can tell you objections to discharge. I have filed thousands of cases, and maybe one or two. It's very, very rare. A no asset case means that there's no distribution to any of the creditors. That's not going to be the driving factor. Because the only reason they can object to a discharge going through in a bankruptcy, they have to have a legal basis to do it. Not just because they're like, hey, I don't want my debt to go away. Yeah, nobody does, except the person filing. But none of the creditors do. They want them all to stay there. And so they have to have a legal basis. It's usually things like fraud, like you incurred the debt through fraud, or another popular one is if the debt is what's called a domestic support obligation, like alimony or child support. Those kind of things you'll see objections raised to. But anything else, credit card companies, that's super, super rare. All righty, let's see here. See what Jose has to say. LVNV funding, debt buyer files a lot of cases, has 4 bills of sale before them. Do they have a chance of proving ownership? You know what, Jose? I am dealing with this. I have a trial tomorrow morning, and it's with LVNV funding, and it's the same thing. They transfer it from original creditor to like this MHC, and then from MHC to it's like Sherman originating the third, and all that. There's multiple. The more times it trades hands, the better your case is going to be. And you need to look at each of those bills of sale. And I can tell you what I do. I go through, you know what? I might have them right here. I was going to pull them up for you. I go through and highlight each bill of sale, highlight the parties, highlight where it says we're going to find which accounts are listed, and then see if there's actually a listing of those accounts. So, for example, if it's from original creditor to Sherman originator, who's one of the ones that LVNV usually buys from, it often will say, look at Exhibit A. If there's multiple transfers, almost never do they have Exhibit A attached to it. They just don't. They'll have multiple bills of sale, and then they'll try to attach one Exhibit A to the very end of it. That's not enough. So you have a good case. The more times that it changes hands, the more difficult it is for them to prove. And when they get into court and they have their own witness from LVNV funding sitting up there on the stand, I try to point out to the court, just really hammer it home that, look, you've got someone from LVNV funding here trying to testify on behalf of like 6 different companies. And they haven't worked there. They haven't been trained by these companies. And the fact that they don't have the proper exhibits to each one is a problem. And so I think you have a good case here. All right, let's see. Jose, new homestead follow-up question here. New homestead limits and being on Social Security income only puts me on judgment, garnish proof status. They won't go away. And sometimes I talk to creditors' attorneys, about things like this, that everything I look at, I try to always look at how is the creditor seeing this person. And I see something like that where they're essentially judgment proof. Judgment proof meaning that even if they get a judgment, they can't collect on it. Part of it is in a lot of states now, the laws are such that these judgments will sit forever. In Arizona, they're good for 10 years, and then they can be renewed every 10 years. And so sometimes they'll just push forward with getting the judgment so that they can, and they'll calendar out 10 years, sit on it, and see if they can collect on it down the road. So ask me unemployment benefits issue. I don't deal with that. Sorry, that is outside my expertise for sure there. So, all right. I think that is it for the questions today. A lot of good questions today. A lot of stuff, a lot of stuff going on. See if I make sure I didn't miss anything here. I think we got pretty much everything. So, appreciate all those questions. I think all of those are excellent questions. Everybody's, I read things on the YouTube channel. People are winning cases. They're, implementing a lot of these different procedures, and it's a lot of work. Keeps you up at night. I always tell people that's the one benefit of hiring an attorney like myself, is that these cases can take over your life, but if you put some effort into it, a lot of times you can get good results. So one last plug for my online tutorials where we do a really deep dive into this, and I provide you with templates and everything. That's over at there's a link for that in the over at YouTube on the notes there, that the consumerwarriorproject.thinkific.com. Go ahead and check that out. All right. I think that is going to what? Okay. I saw Manish said, "Hey, you missed my question." Okay, I'm scrolling back up. We're gonna get this one. Okay. Oh, there it is. Do I need an attorney at the stage of answering a summons as I'm denying due to lack of information? So I always say this. People ask me, do I need an attorney? Well, you're asking an attorney. So I'm totally biased on this. People do well. And like I just said, people are winning cases. They do it on their own. Obviously, having an attorney just helps to alleviate some of the stress And because this is what I do all day long, just like, whatever your job is all day long, you're going to be better at that than I will. So, but the answer stage in particular, the answer is probably the simplest document you're going to have to prepare in the entirety of the case. The issue from there is procedure. And I've seen people, particularly if it's a big dollar case, if you're dealing with anything over 10 grand, it's worth your time getting an attorney for sure. I've seen people with $100,000 cases, they try to handle it themselves. They take a procedural misstep and it causes problems. I do have a template and a tutorial that if you look at that link on the top of it, that Thinkific thing, there is something there that shows you how to draft an answer, and there's a template there. The answer is really just admitting or denying the allegations in each of the numbered paragraphs. Do not go into really anything more than that. That's the biggest mistake I see, is that people put way too much information. They go into why they went into default. They go into why, different settlement offers, that kind of thing. It's not necessary and can actually be harmful to your case. So I would check some of that out. Those tutorials are helpful. They are, I do charge for those, just that's, to be transparent there, but they're a lot deeper dive than what we're doing here. So, all right, this will be, Chrissy, we're doing the last question for you. You live in Arizona. You just had a garnishment entered against you when I was never served. I hear that fact pattern 20 times a day. Seriously, it happens so much. I want to know how I can get this judgment vacated. Should I call you tomorrow? Give me a call tomorrow. If you give me a call, give my office a call. We can set up a time to talk. This happens a lot. And here's how it happens, because when they go to serve you, particularly really old judgments, like I just said, judgments are now good for 10 years in Arizona. What happens is, they would try to serve you. They couldn't find you. You were at work all day and they could never get you homework because the rules require them to place that lawsuit right in your hand. If they don't do that, then they can go to the court and ask for permission for what's called an alternative service order. Nowadays, what they're allowing them to do is they will send it in the mail. They'll come and post it on your door, and people tend to see that. Back 5-10 years ago, Arizona used to allow what's called service by publication, where they would put it in the classified section of some little town somewhere. No one's going to see it. And then 20 days goes by and they enter a default judgment against you. It is possible to get file a motion to vacate. But the thing is, what you have to look for, there's something called an affidavit of service that the process server files with the court. You need to get a copy of that and see how it is that they're claiming they served you. The burden is then on you to disprove what the process server says. So there's shifts. The burden shifts to you to disprove what it is that they're alleging. And sometimes that can be hard to do. But sometimes, it can't be just something of you saying, no, I don't remember. You're going to actually have to come in with proof. Like one time I had a client come in and they said, hey, they're saying I got served on this date at this time. She goes, I have documented proof I was in Wisconsin at a wedding. And we actually pulled up Facebook for the court to show the pictures, the timestamps. We had, the invitation, all that, and the court set it aside. So, all right. Let's see here. All right. Yeah, it is. The debt buyers, there was a big article in the Wall Street Journal. Many thought, during COVID, particularly during 2020, the debt buyers, they're going to lay off a bit. They just pushed the pedal down. They went forward big time on that. Encore Capital, who is the parent company of Midland Funding, they filed more lawsuits in 2020 than they ever have in any prior year. So I guess that is what it is. All right. Well, hey, thanks for checking in tonight. Again, go check out that Facebook page or check out the tutorials if you think they would be of help. Appreciate all the questions and all you checking in tonight, and we'll catch you next week.